Surprisingly, states did not want a vital safeguard recognized in Article 36 to be a hostage to allegations of espionage made by the host state. The absence of such exceptions in the Vienna Convention is unsurprising because the fundamental principles of due process recognize that the more serious the charge, the greater the need for procedural safeguards. Besides, there are some basic rules that must prevail between civilized nations and cannot be displaced by unilateral allegations leveled by the receiving state. Recognizing that the needs of security and efficacy of investigation may require the receiving state to withhold the notification of arrest by a few days, the draftsman of the treaty built in some play in the joints by using the phrase, open quote, without undue delay, close quote. A state may be able to explain a few days' gap between the arrest and the notification if time is spent bona fide in investigating matters relating to espionage before the sending state of the national is notified. It is one thing to explain the lapse of time between the arrest and the notification to the home state, and quite another to suggest that charges of espionage jettison Article 36. Pakistan quotes Sir Arthur Watts QC in his authoritative commentary explaining the ILC draft convention. In his commentary, Sir Watts explains the manner in which the interests of a state in a criminal investigation were balanced with the right to consular access. In paragraph 6, which is extracted, he states, and I quote, "The expression without undue delay used in paragraph 1b allows for cases where it is necessary to hold a person incommunicado for a period for the purposes of criminal investigation," close quote. The commentary explains how paragraph 6 accommodates the need of a state to conduct investigations during which it may hold a person incommunicado. This would perhaps be unnecessary if serious allegations of espionage and terrorism would jettison Article 36. Pakistan draws attention to comments made by Mr. Tunkin, the chairman of the International Law Commission. While he was mentioning espionage cases, he suggested that it may be desirable that local authorities should not be obliged to inform the Council. But the chairman remarked that if the Commission went into the question whether cases of espionage should be made an exception to the whole principle of consular protection and communication with nationals, would have to be reopened. The extracts suggest that the problems of espionage was very much on the table, and yet no exception was made to such allegations in the language to Article 36. Pakistan asylum and in situations of dual nationality. Both these also establish that the Vienna Convention is indeed the exhaustive rubric. The provisions of the Vienna Convention that provide the basis for resolving situation, finding solutions consistent with the Convention. One of the matters brought up by Pakistan is an application of Article 36 to a person of dual nationality, which presents legal challenges, no doubt, with us sua generis, but they need not be explored in this case. Pakistan gives a series of examples which in its assertion are historic and modern examples of espionage that states often operated on the footing that they were not entitled to or were not going to be able to gain access to their espionage agents when they had been captured. India submits that the material relied upon for what happened in those cases is hardly reliable, for it is wanting in relevant detail. The plain language of a treaty, if it is contrary to the conduct of states, cannot be whittled down by reference to state practice. A treaty, in fact, is set about at times to bring about uniformity in state practice. So even assuming that the conduct of states evincing a consistent conduct, which is sufficiently clear, documented so as to satisfy the rigorous standards of what constitutes state practice, it cannot alter the plain language of a treaty. The random examples given by Pakistan in any case do not assist the court in coming to any such conclusion of state practice. On the contrary, recent instances of arrest by China and Russia, facts in public domain, of persons on allegations of espionage based on information in public domain show that the conduct of the receiving state was compliant with Article 36. These the court would find in the judges' folders at tab 1 and 2. Pakistan in this misadventure does not push it to the point of suggesting that there is an established practice to show that consular access is invariably denied in such cases. Individual incidents can then at best establish that Pakistan may not be the only state which has violated Article 36 of the Vienna Convention or similar provisions in bilateral treaties that preceded the Vienna Convention. There is no material place that would establish that giving consular access prior to extracting a confession would have so imperiled its national security or so hampered the investigation that consular access was denied. There is no explanation for giving consular access after that also. I now move, sir, to a discrete issue, the 2008 bilateral agreement. In no official communique to the Government of India has Pakistan ever suggested that consular access to Jadhav was circumscribed by the 2008 agreement. Apart from a reference in a press briefing by a spokesperson of Pakistan government on 20th April 2017, the bilateral agreement of 2008 was never referred to, and rightly so. The question of consular access, provided for under Article 36, is being circumscribed on account of provisions of a bilateral treaty does not arise. Article 36 is the provision of a multilateral treaty, and bilateral treaties covering the same subject matter can be accommodated as long as, and I quote, they are treaties confirming or supplementing or extending or amplifying the provisions of the Vienna Convention. This is the clear language of Article 73 of the Vienna.